Hi, everyone. We're going to give just a couple more minutes. There was a small issue on our end, so we'll wait a couple more minutes for folks to join, and then we will get started.
Hello, everyone. This is Tracy Wright from NCCASA, and I want to thank you all so much for joining us for the webinar today. I am super excited to turn things over to Sky David. Please know that this webinar is being recorded. We ask that if you have any questions, please drop those in the chat. Super excited for Sky to guide us through the new Title IX regulations, understanding that she has read and comprehended and will guide us through 2,000 pages worth of adjustments and adaptations to current Title IX regulations. And know that NCCASA will continue to have conversations like this, understanding that these regulations were presented in a truly unprecedented time, to say the least, and we'll continue to provide TA as well as resources to you all from a Title IX perspective, from outreach, from prevention, whatever your needs may be. Thank you so much, and I'll turn it over to Sky David.
Thank you, Tracy. And yes, thank you for joining this webinar. We know that the Title IX regulations, the finalized version came out on Wednesday. So there has only been a few days to really go through all of this, but we have gone through them and been talking to other advocates. And just a quick plug, if you are a campus partner in North Carolina and not part of the campus consortium, it's a really valuable resource for both NCCASA and NCCADV domestic violence, for campus advocates and campus folks just to share resources, knowledge. And so small plug for Campus Consortium, which Tracy co-heads. And if you're interested in that, please do just shoot us a message. My email's at the end of this. As we get started, I just want to drop a quick word about language. So generally I would use survivor perpetrator language or harm doer language, but in Title IX regulations and in the campus community, that language is complainant respondent or reporting party and responding party. So that's the language that I'm going to use just to keep it consistent. That language is akin to plaintiff, defendant, if you're not familiar with the language. And when someone is found responsible in a campus setting that is just a finding of responsibility, or they were found to be not responsible for the charges. That's akin to guilty, innocent. And I just want to say and lift up that I do recognize and understand there are survivors listening, and I want to note that this is for consistency, not my personal preference. Like Tracy said, if you have questions as we go along, drop those in the chat box, and at the end, we will get to those questions. For starters, I'm just going to go through the process, how we got to where we are, where the next steps are for campuses, and then I will go through kind of the big bucket issues as well as some wins that advocates got during the process. So the first time that we saw a version of these rules was in November 2018. And since then, there was a notice and comment period, and the Federal Register extended the time frame for that because it received the most comments in one day than any other rule. And there were a total of 124,000 comments on this specific rule, which is incredible and really speaks to how important this is to advocates, to survivors, and campus communities all over the United States. Just of note, this was the first formal notice and comment process by OCR since 1997, and these rules will have the rule of law behind them, and the Obama regulations did not. Those were guidelines. And advocates have been working for years on meetings with ORA, voicing concerns over specific aspects of the rule, and some of these were changed. So during that last period of the notice and comment, folks could make an appointment with ORA, whether that was on the phone, and it's kind of your last stop before the rule goes into place, on the phone or in person. And so advocates really worked together to make sure that we were on the same page about things that needed to be changed. And the final rule was released on Wednesday, and there's an implementation start date of August 14th. But that comes with a caveat that many groups, including the National Women's Law Center, Know Your Nine, have already publicly stated they're going to challenge this in court. So that just means that the rule could be delayed or maybe never be implemented if a court makes that finding. So that's where we are now. Campuses have the final rule and have to implement it by August 14th. I'm just going to start with some advocate wins from draft versions. And since 2018, so for the past almost year and a half, advocates have been addressing issues with the proposed rules, both with online and during the ORA meetings, which concluded last month. And so some positive changes that I want to go through include fraternity sorority houses are explicitly included in the final version of the rule. I'll go over this more later. That just means that if an alleged instance of sexual harassment happened in a fraternity or a sorority recognized by the campus, that it would be included. Standard of evidence. Previously, the rule said if a school could choose to employ the school could choose to employ the preponderance of the evidence standard only if that's the recipient, which is the school, uses that standard for conduct code violations that do not involve sexual harassment but carry the same maximum disciplinary sanction. And this final rule stated that a school could choose either preponderance of the evidence or clear and convincing, but must use the same standard for employees. Some of the biggest issues in the rule, and like I said, I'm going to flesh these out more as we go along, includes mandating live hearings by adjudicators who are neither the Title IX coordinator nor the investigator. Evidentiary standard is allowed to be raised from preponderance of the evidence, clear and convincing. Off-campus incidents, and that would include the unofficial frat and sorority houses versus the official ones that are included in the rule. Again, cover it in a minute. Cross-examination by the party's advisor of choice, removal of that 60-day timeline, narrowing of what sexual harassment is, mediation, allowing for religious exemptions, and the same school requirement. All of these I'm going to go over as we go through some of the issues in the rule, but this is kind of your top line items that we are going to be focusing on today. And like Tracy said, there are thousands of pages in this rule, so I won't be covering everything, but I'm going to kind of cover those big buckets. So I'm going to go in the timeline of when the school finds out about an incident and changes that happen along that way. So the first issue that we're going to cover is notice to school. Notice is triggered in this rule when in K-12 context, and it's important to remember that Title IX not only affects the campus communities, that's something that I think a lot of people forget about, that this also has to be implemented in K-12 institutions across the nation. So it carries a lot of responsibility. And in K-12, allegations of sexual harassment have been disclosed to any employee of an elementary or secondary school. So the school has notice when anybody within their school receives notice of an allegation. And we should note that this also triggers mandatory reports within North Carolina, as long as the person is under 18, and in most instances they're going to be. And we're all mandated reporters in North Carolina, so please do remember that that comes with kind of a double standard for what you need to do. In a campus setting, the rule does allow for flexibility to decide who's a mandatory reporter, or to designate some employees as confidential resources to discuss without triggering a Title IX report. So similar to the previous guidelines, you don't have to make everyone on campus a confidential resource or a mandatory reporter. You may want advocates or some folks in the campus community, RAs, to be confidential resources, so that if a student wants to come disclose an instance of sexual harassment and they don't want to make a report, it's not going to automatically trigger where that person then has to turn it in to the Title IX coordinator. And so they're leaving that up to campuses to figure out for themselves. In both K-12 and on campus, once a Title IX coordinator or an official with authority to institute corrective measures on the school's behalf has knowledge of the allegation, it triggers the school's response obligations. As far as these response obligations go, this is a change from the previous guidelines. Now there is a deliberate indifference standard. Schools must respond to sexual harassment in a way that's not deliberately indifferent, which means that the response is not, quote, clearly unreasonable in light of the known circumstances. And what are those mandatory obligations? Schools have to provide supportive measures to the reporting party, not restrict rights such as the First, Fifth, or 14th Amendment, and respect the reporting party's wishes as to whether the school investigates. And if allegations do not meet the standard in the rule for sexual harassment or don't occur on campus or within an educational program or activity, the school does not have this obligation. We'll cover those later. Another pretty large issue, and one that has been debated for the last 2 years since the original proposed version came out, is the religious exemption. So this was not changed, and I should say that there is a specific exemption for religious institutions to be exempt from these obligations. This is done by the school submitting in writing to the Department of Education Assistant Secretary a statement by the highest ranking official of the institution identifying the provisions that conflict with a specific tenet of the religious organization. And the school can assert this exemption without approval by the education department. Well, what's that mean? That means that the school can just say, we don't have to respond to this because we have this religious conflict. And then if there is a complaint filed and the school becomes under investigation, then they can raise that to the Department of Education. It doesn't have to be in the correct order. If a school does assert that exemption, they can raise it, quote, at any time, and that language is lifted from the rule. The previous guidance was that any campuses that receive federal funding, K-12 campus, and including religious or private schools, they were all bound by Title IX. And so this creates that religious exemption and does not require all folks who receive federal funding, which is pretty much every university, to abide by. This is another really big issue in the rule, the location of the violation. So the Title IX statute applies to, quote, persons in the United States with respect to education programs or activities that receive federal assistance. Specifically here in the United States and with respect to education programs or activities. The final rule states that schools must respond when sexual harassment occurs, quote, in the school's education program activity against a person in the United States. Again, this is being taken very literally. So it does include location, events, or circumstances in which the school exercised substantial control over both the respondent, the context in which the harassment occurred, and includes buildings owned or controlled by a student organization that's recognized by the school. This limits violations at a particular school to only students at that institution. If an assault were to happen between a complainant and respondent, and the complainant attends University X and respondent attends University Y, which is right across the street or a sister school or whatever that may be, and the complainant is assaulted on their campus and it's against that student, the school wouldn't be able to then have jurisdiction over that student. This is a large difference between the previous guidelines and the current regs, or it also, if you were assaulted or there is an allegation of sexual harassment across the street at that school, you can't then ask your school for protection against that person. So you can see how this could play out. I should also note that that United States is really specific because in the 2018 rule, proposed rule rather, this was included and there was a lot of discussion about study abroad. If you are in a study abroad program through your school and you are somewhere else but still under the control of your school, what does that mean? And this rule makes it clear that that would not be a Title IX violation. But as I have noted at the bottom, schools may address sexual harassment that's outside their jurisdiction by any manner the school chooses, such as supportive measures or discipline. So a school could choose to say, look, you violated our code of conduct. Maybe you didn't violate Title IX, which is an extra level, but you violated this code of conduct. And for that reason, we're gonna take disciplinary action against you, but it wouldn't be the same as then immediately triggering a Title IX violation. And as it says, the school can still choose to provide supportive measures. So they can still decide to help that student, but they just don't have an obligation to. All right, moving on to the definition of sexual harassment.
We actually have a few questions in the chat.
Okay. You want me just to go ahead and get to a few of them?
Yeah, just while we're still on the topic.
Okay.
So the first one was, what are some of the reasons given by institutions who want to take advantage of this religious exemption?
So I think that the religious exemption language comes because religious schools state that it would be against their personal belief system to be litigating these cases. There isn't really an example in the text that we have and in the comment and response period where folks argued for the religious exemption. I can't recall a specific scenario, but it would have to be some sort of conflict with their religion.
And then I'm not sure if you answered the next one. So violations among students on study abroad together are no longer covered? Question.
That is right. They are no longer covered.
Okay. And does it cover assault harassment by staff faculty?
It does. And it does say that if you are going to use clear and convincing standard of evidence or preponderance, either way, you have to use that same standard of evidence for staff and for students.
Mm-hmm. Would the religious exemption give schools an out for same-sex sexual assault?
If they chose to be exempt from Title IX purposes. So the school could still discipline under their code of conduct or some other disciplinary action. But yes, they could choose to do that.
Okay, and last question, how do Cleary and VAWA intersect with these new regs? Are there any areas of disagreement?
So that's a great question, and we will cover that.
Okay, awesome. And then to clarify, and clear and convincing evidence is a higher bar than a preponderance of evidence, right?
Yes, it is a much higher bar. So I will get to that issue as well. But if you want me just to cover it really quickly, your preponderance of the evidence is 50% plus a feather. So more likely than not. And your clear and convincing is your criminal standard of proof. So there has to be, well, clear and convincing evidence versus just more likely than not. And in civil court, you use preponderance of the evidence, and in criminal court, you would use clear and convincing. The theory being that this is more like a civil court. This carries no criminal punishment. You don't go to jail. This is more akin to a civil court.
Okay. Thank you, Sky.
Yeah. Okay, definition of sexual harassment. The final rule defines sexual harassment to include any of three types of misconduct on the basis of sex, all of which jeopardize the equal access to education that Title IX is designed to protect. This language is lifted directly from the rule. Any instance of quid pro quo harassment by a school's employee, any unwelcome conduct that a reasonable person would find so severe, objectively offensive that it denies a person equal educational access, any instance of sexual assault as defined in Cleary, dating violence, domestic violence, or stalking as defined in VAWA. So there's kind of your answer with Cleary and VAWA. They use Cleary and VAWA as guidelines. That 2018 proposed reg, that it had some that did conflict with Cleary and VAWA, and that was one of the comments that kept coming up, was that this was conflicting with constitutional law, conflicting with Cleary and VAWA. So the final rule tries to align itself more with both of those. It does also prohibit sex-based misconduct in a manner consistent with the First Amendment. Quid pro quo harassment and Cleary Act VAWA offenses are not evaluated for severity, pervasiveness, offensiveness, or denial of equal educational access because it's sufficiently serious to deprive a person of equal access. But that any unwelcome conduct language that you see at the beginning, compare that language to the language below, which says previous guidelines defined it as unwelcome conduct of a sexual nature. That includes unwelcome sexual advances, requests for sexual favors, and other verbal, nonverbal, or physical conduct of a sexual nature. So opponents of the previous guidelines argued that this was a really broad definition. And it is a really broad definition, the previous guidelines. If you take a look at that, you could see how one might argue that. And so the rule felt that, or the education department felt that this rule was more narrowly tailored, but it does significantly limit who can bring forth a Title IX claim. But there is a major positive in this, and stalking was not included in previous guidance, and now stalking is in the rule as it's defined in VAWA. So that is a really big chunk that is now covered. More on sexual harassment. They use the Supreme Court's Davis definition. In that case said severe and pervasive and objectively offensive conduct that effectively denies a person equal educational access is one of the 3 categories of sexual harassment. So that where unwelcome sex-based conduct consists of speech or expressive conduct, schools balance Title IX enforcement with respect for free speech and academic freedom. And that free speech and academic freedom language, that is what you heard a lot in court cases that have come out since the Obama era regulations, talking about respondents in these cases who brought cases against the schools, where they said that the Title IX process interfered with their free speech rights and denied them educational access. So that's kind of where that language comes from. And it also uses the Supreme Court's Title IX specific definition. And previously they used the Supreme Court's Title VII workplace standard, severe or pervasive conduct creating a hostile work environment. The First Amendment concerns differ in educational environments and workplace environments, and the Title IX definition provides First Amendment protections appropriate for educational institutions where students are learning and employees are teaching. Students, teachers, faculty, and others, they believe, should enjoy free speech and academic freedom protections, even where speech or expression is offensive. So a quick example of this is that you have a Title IX complaint filed, and the complainant files this to Title IX, and the respondent then begins to talk about the complainant on campus and argues that that is their free speech right. You could kind of see how these could line up on a college campus, and the complainant could go and say, this is a violation of my rights, and the respondent says, no, that I am just exhibiting free speech. So that is something that they felt that they were protecting in this rule. Another big bucket issue is the time frame. The rule does require, quote, reasonably prompt timeframes for conclusion of the grievance process. And just a side note, the grievance process is from complaint filed to conclusion of the investigation or case or hearing, wherever that goes. If there's not a hearing, the conclusion of the informal process, or when a complainant decides they want to withdraw. Whatever that may be, where there is a conclusion, that would be the conclusion of the grievance process. And that includes reasonably prompt timeframes for filing and resolving appeals and informal resolution processes. If the recipient, which is a school, offers informal resolution process and a process that allows for the temporary delay of the grievance process or limited extension of time frame for good cause with written notice to the complainant and respondent of the delay or extension and the reasons for the action. So the previous guidance said that campuses should finish the grievance process within 60 days, but it didn't mandate that time frame. And they said because complex investigations with multiple reporting parties or multiple reported parties may take more time. My note at the bottom, it is unclear what would or would not constitute a reasonably prompt time frame. Is 180 days reasonably prompt given a specific fact-based scenario? And I think that this is going to be something that will be a case-by-case basis. If a student wants to challenge whether or not the school did complete in a reasonably prompt time frame, it would just have to be examined based on that fact pattern. The next issue is a presumption of innocence. Under a school's grievance procedures, the respondent must be presumed to be not responsible, so that a, quote, finding of responsibility only comes at the conclusion of the grievance process. This is not a specific rule change, but rather was an assumption that parties will be treated equitably during the process before. So this just states that you're innocent until proven guilty. This kind of goes along with hearing that campuses we're instituting this process where someone was guilty until proven innocent. There wasn't due process. So this is more flowery language than anything else, is what I would say. It is not, it doesn't change anything. Issue mandatory and discretionary dismissals. So when a school gets the complaint, they must dismiss it if it does not meet the definition of sexual harassment, like we covered, or alleges sexual harassment that did not occur in the school's program or activity. Let's say you and another college student, you being a college student, went out to eat and to a party off campus, and there was alleged sexual harassment or an assault at that party that did not occur within the school's program or activity, or alleges sexual harassment that did not occur in the United States, again, study abroad. Under the new rules, a school may dismiss a complaint if the complainant informs the Title IX coordinator they wish to withdraw some or all the allegations in the complaint. And as it says, they may dismiss. So Title IX may choose to move forward with a case, even if it's not within that complainant's wishes. And that was happening anyway. If the respondent is no longer enrolled or employed by the school, so they can decide, let's say you start the Title IX grievance process, complaints filed. Once the respondent receives notice of that, the respondent then transfers schools. The school may make that decision based on whether or not they want to continue when the alleged conduct happened. That person was enrolled at the school, but now they're not. So that's just a discretionary tool for schools. And if circumstances prevent the school from getting sufficient evidence to reach a determination.
Hey,
Which, by the way, that,
another question.
okay, yeah, sure.
So it's not saying the complainant has to come forward with a certain time frame. It's just saying that once they do come forward, things have to happen quickly, right?
Yeah, so generally, there is no, like, you have to report within 48 hours or anything like that. There's not a statute of limitations. Just as long as you're a student, you can bring that and you meet the other criteria. And I would say that even under the proposed guidelines, previous guidelines, where there's this quote, reasonably prompt time frame of 60 days, where that was your guide. I'm not sure how that really differs from now. Although I think you could have more reasons to delay the whole grievance process now, but I don't know that I've seen a case that started and finished within 60 days anyway. So that is something to keep in mind. It wasn't like all of these were all completed within 60 days and now they're going to be years long. Like, schools were finding ways around that anyway.
Thanks, Guy.
Yeah. Other questions?
No, it looks like that's it for now.
And just to note, under the mandatory and discretionary dismissals, I covered this earlier, but again, a school could bring some sort of disciplinary action, even if they dismiss a complaint. It just would not be under the Title IX regulations.
It looks like we have one more question.
Okay.
What if two universities share an academic building, like a library or classroom building, with sexual harassment against a student from school A by a student from school B have to be dismissed?
This is really interesting. That is a great fact-based scenario. So in this instance, student from school A is your complainant, and I would say that yes, the school would have to investigate because they do assert substantial control over that building. Both schools would have that same sort of control over the building. So if the student B goes to a different school, I'm sorry. Is that right? student B goes to a separate school?
Yeah.
Yeah, so then they would have to dismiss, because student B, they wouldn't have jurisdiction over student B. So sorry, I played that through as far as the school building itself. They have that substantial control, so check that off, but they still don't have jurisdiction over a student at another school. And we'll cover that a little more as well, because that is a pretty big change too. Okay. Moving on, issue of mediation, informal resolution. Schools cannot compel parties to participate in an informal resolution process and can't offer it unless there is a formal complaint. And a formal complaint is either once there is a complaint filed by the complainant, or the Title IX coordinator signs off on the original complaint. So simply talking about it is not enough, or just reporting it to someone. You have to have that Title IX complaint. Mediation or informal resolution cannot be used when there's an allegation between employee and student. So the rule does say if there's an employee-student situation, they're not going to allow mediation. Parties do have to voluntarily consent to the process, and that must be written consent. And any time prior to agreeing to a resolution, either party may withdraw from the process and resume with the formal complaint process. And the formal process ends in a hearing versus this informal complaint process, which would be mediation or some sort of informal resolution where the parties sit in the same room. Previous guidance did hold that mediation is not appropriate, even if voluntary. It's unclear in this section. The rule uses broad language around the facilitator of an informal process and who could serve in that role. So this is a pretty big issue for advocates. Specifically, it's well thought that mediation is not appropriate in cases of sexual misconduct, and the rule does allow for that. I think I have seen at institutions who are using it already, some sort of mediation or informal process. And there are instances where the complainant may want to do that. But I have seen instances where schools tell a complainant that this is the easiest or the fastest way to finish a complaint, so that's why you should choose it. And then they feel a little bullied into that. So that, I think, is a fear and re-traumatizing a complainant when they have to sit in the same room as the respondent, even if they had voluntarily consented to it. Once they sat down there and they feel like they have to go through with that, could lead to some potential harm. I thought I saw that there was a chat. No.
Yeah, we had one person that said, can I just clarify, schools never did have jurisdiction over students that weren't theirs. We can always provide support, accommodation to complaints, but we can't hold individuals responsible for behavior if they're not our students.
I want to clarify as well. I think this is an instance where reasonable people could differ in their opinions. I have seen cases that did allow for that at schools, and I have active cases right now. So I think that it wasn't a broad ban on that. Maybe guidance said that.
And one more question. Do you have a sense of who will likely end up in that facilitator role for the mediation process?
So again, that's unclear in the rule. I would say that, let me pull this up. It does say that that person has to go through training, but it just says that they must be trained prior to the informal process. So I think that would be up to the discretion of the school to decide who they feel would be appropriate. Just like now, your hearing panels and some schools that do offer informal processes allow different folks to serve in those roles. I think that would, again, be up to the schools to decide as they develop their policy for this. All right. Another issue is that there is a live hearing requirement in this final rule. The rules require that the post-secondary institutions have a live hearing, so campuses have a live hearing unless parties have agreed to the informal resolution process. The decision maker in the live hearing cannot be the Title IX coordinator or the investigator. So it at least has to be a third person. And quote, at the request of either party, the recipient must provide for the live hearings that occur with the parties located in separate rooms with technology, enabling the decision makers and parties to simultaneously see and hear the party or witness answering questions. This requirement is not in the K-12 capacity. This is a change from previous guidance. It did not require live hearings, but in the cases of live hearings or the hearing process itself, previously, they allowed for that technology piece. Most institutions really kind of have this down now where they allow parties to go in and out of the room. And they have different hallways. They make sure that the parties don't cross. But this just does require that live hearing unless there is an informal process. So some schools I know in North Carolina currently do not have a hearing process. They just have the parties going back and forth with questions, and then they come to a conclusion from that, and that would change under this rule. What's unclear in this section is other guidance on the decision makers. Similar to the informal facilitator, it doesn't say who can or cannot be a decision maker other than it cannot be the Title IX coordinator or the investigator. Gabrielle, was there a question here too?
No. Tracy said informal processes have also led to discussions around restorative justice practices as well. And then you actually did have a question come in. I'm having trouble understanding the second bullet. Can you explain again?
Sure. So either party, either the complainant or the respondent, can ask for the parties to be in separate rooms with technology. But if they are in separate rooms, they have to still be able to see and hear the person answering questions. So either party.
Hey, Sky, I think your audio shorted. We stopped hearing you.
Sky, are you back?
Yeah, I'm here. It was just breaking up a bit for me. I'm sorry.
Okay.
Can y'all hear me okay now?
Yeah.
Yep.
In regards to restorative justice, the final rule does allow to facilitate informal resolution options. And then all it says is, quote, such as mediation or restorative justice, so long as both parties give that voluntary consent. So what I would say is that Tracy said this during our campus consortium meeting. I will reiterate it. If you want some training on restorative justice or want to know what that looks like on your campus or how it could be better, we are more than happy to provide that training. And by we, I mean email me or Tracy or whomever at NCCASA. We are happy to come to your campus and have discussions with you about this, or I guess during this time, virtually talk about it. All right. So during that live hearing, another issue that I think has been covered pretty heavily is the cross-examination issue. The previous guidance in 2011, 2014 discouraged cross-examination by the parties during a hearing. And that would be direct cross-examination by, complainant questioning respondent or respondent questioning complainant. The rules say that, quote, the decision maker must permit each party's advisor to ask the other party and any witnesses all relevant questions and follow-up questions, including those challenging credibility. Such cross-examination at the live hearing must be conducted directly, orally, and in real time by the party's advisor of choice and never by a party personally. So that is in the rule. And if the party does not have an advisor, the school must provide free of charge an advisor for the purposes of cross-examination. It does also state that only relevant cross-examination and other questions may be asked of a party or witness. And it explicitly states that questions and evidence about the complainant's prior sexual predisposition or prior sexual behavior are not relevant unless such questions and evidence are offered to prove that someone other than the respondent committed the conduct alleged by the complainant, or if the questions and evidence concern specific incidents of the complainant's prior sexual behavior with respect to the respondent and are offered to prove consent. So this is good. I should say that it is great that it says that the parties cannot question one another personally. That actually was not in the previous guidance. Like I said, it just discouraged cross-examination by the parties during a hearing, and now in law it's going to say that never can you have a party question the other party personally. And if it is a case where one party does not have an advisor, whether that be an attorney or an advocate or a parent, whoever is with that party, if they don't have that person, someone else will come read their questions. It won't just default back to the student. And it does have that rape shield in it, but there are instances where the parties could ask other questions. And what I'm going to note about that as well, as far as relevance goes, all of the questions that happen at a live hearing, the rule does provide that those questions have to first be vetted to the decision maker. So if I'm someone's advisor, if I'm your attorney during the hearing and I want to ask the question of credibility or any question, I first say it to the decision maker and they say yes or no, and then the responding party can respond to the question. So that fifth bullet point could seem like it could get a little dicey as far as someone saying they consented before, so this was consent now, even though that's not how consent works, and trying to prove that they had previous instances of consent with responding party and use that as evidence that there was consent this time. Like, you could see how that could get a little bit dicey, but there will be that requirement that those questions go through the decision maker first. Unclear in this, how many advisors a party is entitled to have in their hearings. I know right now some schools say one, some say two. That is not outlined in the rules. Moving on to appeals. The rule states that a school must offer both parties an appeal from a determination regarding responsibility and from a school's dismissal of a formal complaint or any allegations therein on these three bases: procedural irregularity that affected the outcome, new evidence that was not reasonably available at the time the determination regarding responsibility or dismissal was made that could affect the outcome, or the Title IX coordinator, investigator, or decision maker had a conflict of interest or bias. Previous guidance recommended that schools provided an appeal process, but they didn't outline guidance for what that looked like. So different schools had different appeal processes. and different criteria for who could bring an appeal and what that could be based on. Retaliation. The rule explicitly prohibits retaliation, stating that no person shall intimidate, threaten, coerce, or discriminate against any individual for the purpose of interfering with any right or privilege secured by Title IX, or because someone has made a report or complaint, testified, assisted, or participated or refused to participate in any manner in investigation, proceeding, or hearing. This is new language, and there is specific new language that says charges against an individual for code of conduct violations that do not involve sex discrimination or sexual harassment, but arise out of the same facts or discrimination or report or formal complaint of sexual harassment for the purposes of interfering with any right or privilege secured by Title IX constitutes retaliation. I think this is really big because it means that if someone brings a charge against a complainant and it is clearly for the purposes of interfering with the investigation, that can constitute retaliation. So let's say the respondent brings what would be a counterclaim against the complainant here just to make sure that it would stop the first investigation and trigger a new investigation. If it arose out of those same facts, then that would be retaliation or could be considered retaliation. It does also note that a false statement made in bad faith is not retaliation. And as I noted at the bottom here, it specifically clarifies the exercise of rights under the First Amendment do not constitute retaliation. Like I said at the beginning, that would be an example where a complainant files a complaint and you have a respondent who is upset or whatever that may look like for that respondent, and then, you know, starts talking about the complainant or whatever, that talking about the case itself, whether that is just an exercise of their First Amendment rights or not is something that the school can determine. But if they do determine that it is a First Amendment right, that would not be retaliation. Some of the issues not addressed within the rules, one really big one is a uniform definition for consent. That's something that schools are going to have to come up with on their own. A lot of schools already do have really strong definitions for consent within their code of conduct, but it does reference in the rule specifically that they are not willing to make a policy determination for what consent means across the country. It also doesn't include specific training for those involved in the process beyond, quote, training on the definition of sexual harassment, the scope of the recipient's education program or activity, how to conduct an investigation and grievance, and how to serve impartially. Among these, kind of the other things that I said are a little unclear from the rule, those would also be included in things not addressed. There's just plenty of things that are unclear or that the education department clearly wanted to defer to individual campuses. I made this little chart, and when we finish the webinar, I think Gabriella is going to send this out with the slides. This kind of shows you the process because it can get a little janky if you're just thinking it through in your head. Once a school is put on notice and they have that actual knowledge, then they move down and say, does this complaint meet the standard for sexual harassment? And they look at, you know, VAWA, Cleary, and then the definition for sexual harassment. If it's no, the school must dismiss the complaint for the Title IX purposes. Again, could use other disciplinary measures. And then if yes, did the sexual harassment occur in a school's education program and was in the United States? No, again, they must dismiss. But if yes, and both students are at that school, the school now has a mandatory response and must investigate and provide supportive measures to parties. Then we move into investigation, evidence gathering, and where you would have a report issued. And any time during this time, the parties may agree to that informal resolution process, whether that is a restorative justice process or if it is a mediation process, that can happen anytime during this period. If not, there is a live hearing required for campuses. That's optional for K-12. And after the live hearing, the decision maker issues a written determination of responsibility that goes to the parties simultaneously, and then either party may appeal the decision on the outline basis. One of those three metrics are met, and then that is the conclusion of the Title IX process under the new rules. I thought I saw a question just pop up.
Yeah, it was, what was the second point of the last slide? Issues not addressed in these rules.
Specific training for those involved in the process, like your coordinators or decision makers. But it does say that they have to have training on the definition of sexual harassment, the scope of their education program or activities, how to conduct an investigation and grievance, and how to serve impartially. All right. Any other questions that y'all have? Do we provide training to schools? We do provide training to schools. So just shoot me an email, yes, or Tracy. You can see my email is sky@nccasa.org here. Tracy's is tracy@nccasa. They're fairly easy to figure out if you know one of our emails. Please do just shoot us an email and we will get that set up. Yeah, thank y'all so much for coming. If there are no more questions, again, these slides will be sent out. And if you have specific questions about your campus policy or your K-12 policy and you're looking for some guidance, please just reach out to us. We are more than happy to talk through these issues with you. There are some places where you could be more clear, and you should note that these are kind of bottom bar for what you have to do under the federal guidelines.
Everybody, let's please give a virtual round of applause to Sky for reading 2,000 pages worth of information and clearly articulating things that our campuses need to think about to be safe. So grateful for that. I learned. Thank you so much, Gabriella, for putting this in place. From last Thursday to garner, we had upwards of 89 folks here today. We will continue to stay in community with you all. Thank you all so much. Everybody stay safe. Thank you so much, Scott. Thank you so much, Gabriella. Everybody have a good one. Goodbye.